Welcome to another edition of The Naked Truth. My name is John Singletary.
And my name is Ramon.
Today we're going to talk about, we, through the Judicial Freedom Riders and with The Naked Truth, we advocate due process and equal protection. Today we have an order, copy of the hearing, and an order that's within the hearing that was done by the Master and Equity Judge Mikhail Scarborough in 9th Circuit, Charleston, South Carolina.
John, before you go any further, I think the title of this one says, Justice is not for all.
Justice is not for all.
Justice is not for all. Go ahead, John.
Okay. Well, clearly, according to this, it's not. This was a hearing that was scheduled by the judge on June 3rd, 2014. And he starts off by saying that I have already prepared an order. Now you come to the hearing as the judge saying, I already prepared the order. I'm not taking any argument. Now a hearing is supposed to allow you the right to be heard. You've got the right to be heard. That's due process. And he starts off by saying, I've already prepared an order. I'm not taking any argument, which means that I've had a predisposition to what, before I even hear the merits of the case, before I hear any argument from either litigant, I already know what I'm going to rule. And he goes on to say the matters before the court are, and he mentions those. He doesn't mention all of them. Goes on down and says that he has determined that a removal to the federal court was a nullity. Now that court, the case had been already in the federal court for probably 3 years, and it was at the appellate court. While it was at the appellate court with an order, a mandate of stay, he decided that it was a nullity. Now if it was removed, only a federal judge would be able to remand it. It was never remanded. They never complained about the removal, and so in effect the thing has been removed. It had already been talked about by federal judges. Anyway, he snatches it back, says that he's determined that it was a nullity, and he goes on to say that it appears that the defendant has now exhausted pursuant of his claims, and goes on, it appears either you have exhausted or not. He had an order from a federal court to leave this case alone. He decided it was a nullity. He decided that I'm not going to allow you the process of appealing to the appellate court. I'm going to go ahead and snatch it back. He goes on and even mentions the Judicial Freedom Riders courtroom of public opinion dealing with this show. He says that we have our own system of justice, which is the untruth. Do we have our own system of justice?
No, we don't.
Okay.
What we try to do here is to give you the facts. Give you the facts. That's it. You can form your own opinion. That's why it's called the courtroom of public opinion. The public needs to be aware of the facts of the case, of these cases that we bring before you, these issues. You need to hear the facts. Now on this, I was a witness to this. That judge didn't even sit down. Judge Scarborough did not even sit down.
Didn't even sit in the chair.
Didn't sit in the chair. He stood up and he read his order. And like John said, on a hearing, what happens in a hearing, we're not lawyers, but what happens in a hearing is that both sides are given opportunity to present their case, because you can have it in writing. However, there's some things that can be expressed more verbally. Am I right, John?
Correct.
So that's why they allow you to verbally plead your case to the judge. Each side gets 15 minutes or so, somewhere around there.
Yeah.
Somewhere around there.
Mm-hmm.
Now, the other side, hey, they don't care because it ruled in his favor. But he's already made a decision before even hearing John, and so he didn't even want John to even be heard.
And he goes on to say that submitted that was a notice that requires the court to recuse itself. It required the court to recuse itself because several things that were revealed were presented to the court that showed that there was impartiality and that there was a reason for him to not be involved in the case. That was known well before. It was known well before we got to court. And so what he goes on to say is that he's not going to hear any more substantive issues from me, who was the defendant, and that he was not going to retain any further issues, and that the court recuses itself from any further involvement in this matter. Okay, so once I brought those things to light, and there were several, and in another show we'll tell you about how to go about doing some research to find out if the judge that sits on your case should be recused, just as Judge Seagar's Andrews was in Charleston, South Carolina. At any rate, the defendant seeks to have his motions heard, and he goes on to say that if I want to be heard, then I had to go and find me another judge. That I had to go find another judge.
45 minutes to find one.
Right, 45 minutes. And after he recuses himself on the issue, he then goes to the next hearing and he is still the judge on the very same matter. Now, I've never heard of a partial recusal where you can say that I'm going to recuse myself right here, but yet on the very same case, that's an hour and a half later, I'm going to come back on the case and now I'm going to administer
It was 45 minutes.
the case. 45 minutes.
Not an hour and a half. 45
Okay.
minutes. You get that straight now. That was 45 minutes.
Reading verbatim what it says, if you want to get your motions heard, I suggest you go find another judge. I suggest you go find another judge. Now, why in the world would a litigant be saddled with the responsibility of finding another judge? They should assign the judge.
Yeah.
And when he determined, obviously prior to him having the hearing, because he said that, you know, he'd already made him not only his ruling, but he's already written it down, and then he calls it a hearing. He brings us into court. Incidentally, this is the same judge that previously ordered me to bring in my own stenographer. Once I got her there, he then said, I'm not going to let you use her. Can't get a copy of the one from, this is what I was told previously, that you can't get a copy of the one from the court stenographer, because if you are pro se, you have to bring your own. So when I brought my own, then he said, well, you can't use it. At any rate, same judge, and now we're dealing with the fact that he refuses to allow you the right to be heard, and after not allowing you the right to be heard, then he recuses himself, but stays on the case. Maybe I'm missing something.
Well, John, maybe you, I think you are, John. You must remember you got to know your place.
Oh,
You got to know.
maybe I need that. Ask the merit selection committee.
You got to know your place, John. You're a black man, okay? And
Born black in America.
Born black in America. You're a black man, and you thinking that just because the law is written and the law is on your side as written, don't you think that standing before that judge that he's going to rule in your favor, even though the law is on your side?
I've even had situations in front of that same judge where I noted the law. He would read it, say, "Ah, that's what it says," but he's not following it. Now, in those hearings, I have been refused to get a copy of, or to be able to purchase a copy of the transcript from that hearing. And when I go all the way up through the South Carolina court administrator, who is over all of the stenographers and court reporters, they tell me, oh, that's the master in equity, and we don't have any jurisdiction to tell the stenographers for the master in equity to do anything, because the master in equity hires their own. Now, this is what South Carolina, the court administrator, who is the highest in the state dealing with stenographers, they tell me that they are not over the stenographers for the master in equity. They hire them themselves, and so they get to do what they want to do. And now he says that the lady's out on sick leave. The lady's been retired. She's not on sick leave, she's been retired. I still don't have the transcripts that I've requested. And this is not the first time. I know of several other cases, same thing, where you are refused the right to be able to get a copy of the hearing.
Well, on my last thing I want to say on this segment about this is that, one, as a black man, we're thinking about black robe, white justice, and John's getting white justice. However, there are white as well as Latinos that also are victims of a corrupt justice system. Just as what John experienced, their organizations. What's the organization that we had contacted about Lawless America?
Lawless America.
Lawless America. You can check out Lawless America, and you can see some of the stuff that they document. Well, we're experiencing that, and I thought after going into defending my country, I thought that the Constitution would mean something to everyone, every American, but it doesn't. Due process, it means nothing.
This has been another edition of the Naked Truth, and we'll see you on the next show.
Please remember that we're starting our membership drive on July the 4th, Independence Day. We want to get 1 million members in 1 year. That's $36 per year, and we need your help to fight this corruption in our justice system. Thank you very much.